Well, I think we're ready to get moving. So again, hey everyone, welcome to our webinar. We're really excited to have you all here. We're going to be talking about some fair housing topics today and doing a little bit of Mythbusters with it. So we're going to have some questions in here. Don't worry if you don't know the answers. We're just trying to see, did you learn some of the things that we were teaching you on, or what kind of knowledge did you have before we kind of got into some of these topics? So we've got a lot to cover. Like I said, we are really excited to have Monica here. She is an excellent presenter. We have had her here in the past and we have her back again. So y'all are really lucky to have her. Monica is a trial attorney and she has over 30 years of experience. She's frequently speaking on the national sphere on topics of property management, fair housing, litigation trends. She's teaching real estate agents, brokers, property managers on ways to reduce her liability. She's constantly swimming in some circles with high-end politicians up in HUD and Secretary of State and interviewing them. And she's really involved in the real estate avenue of litigation. She's based out of Atlanta, Georgia, and her national law practice is often called upon on real estate, brokerage, and property management litigation. So we are really blessed to have her speaking with us again. She is an extremely well-versed person and expert in her field of real estate. So Monica, welcome and thank you for being here again.
Thank you, Ben. What a lovely introduction. It is just great to be back and so excited to share this topic as it is National Fair Housing Month in April and just thrilled to be here.
Yeah, we're excited. And like she said, it's National Fair Housing Month. Shocker, we've got a fair housing webinar here. So we've got a lot of content to go over. So we're going to jump right into it. We're quickly going to go over our agenda just to make sure everyone knows what we're talking about and also who it's relevant to for our audience. So for our property managers, obviously fair housing is a major concern for y'all. We're talking about it here mostly in the application and leasing process. So this is going to help you guys look at, hey, how are we doing this and making sure that we're staying compliant and reducing our liability. For our listing agents or our real estate agents, now I want to be clear. I am not recommending that you do full service property management here. This webinar is to just help you understand some of the fair housing risks that might happen if you are listing a property for a property owner in the leasing and application stage. So this is just to help you guys get your knowledge and understand some of the risks that are there. But I want to be clear that we're not recommending, hey, go out and be a property manager and do a full service property management scale here. This is solely just for informational purposes to help you all if you are listing some properties. So we got three main things that we're going to focus on today. The first one is just kind of fair housing 101, some common risks and best practices. Then we're going to get into specific fair housing topics, and we're actually going to go into some of the keys of, what you need to know and just kind of what is involved in it. And then number three, we're going to go over how do you handle a complaint and also how do you create processes to minimize your risk. So we've got it on the screen. I've got to say this, nothing in this presentation, whether oral or written, is intended to be legal advice. It shouldn't be relied on the same. It's only for educational purposes. If you do have questions, lean on one of your local attorneys to understand the laws and the rules and the regulations in your area. So I just want to be clear, this is strictly for informational purposes and not legal advice. So now that we got that going, let's get into our first topic and go into Fair Housing 101. Monica, could you take a few minutes to just kind of tell us what fair housing is and how it applies to real estate?
Absolutely. So the Fair Housing Act, which is promulgated through the Department of HUD up in DC, makes it unlawful in a real estate transaction, so whether we're managing, selling, renting, etc., to discriminate because of 7 what are called protected classes. And as you see here, Ben, on the screen, they're race, color, meaning color of your skin, religion, sex, meaning gender, national origin, the country from which you have come from, disability, which is we'll talk about later on, which is very expansive, and then familial status, the idea of what is a family. Now, in the last few years, we've had some expansions by virtue of some cases, a case that came out of the Supreme Court of the United States that we'll talk about that included sexual orientation and gender identity as part of the definition of sex. So for everyone on the webinar, they know that if they are a member of the National Association of Realtors or their local state association of realtors or the National Association of Residential Property Managers, they've always been ethically bound not to discriminate based on sexual orientation and gender identity. But now, under the way our law is written, that falls under sex and cannot be a grounds for discrimination. Also, depending on where our friends are across the country, they may have some other protected classes, such as source of funds, where you're getting your funds from if you're renting, like Section 8, or if you are a veteran or have veteran military service in your background. But again, that's very location specific. And then if we look at sort of like the law itself, this is what this is. This is the law. Down there on the bottom where it says 42 USC, that's United States Code. This is the law. And so it's very easy for our realtor friends to just also add in the word sell when we're talking about this. But these are the things that the Fair Housing Act doesn't let you do. It prohibits a refusal to rent or sell, refuse to negotiate for the rental or sale of, or otherwise make available or deny a dwelling. You cannot discriminate against a person in the terms, conditions, renting, or sale of a dwelling, or in the provision of services or facilities in connection with that. And you can't represent to someone that a dwelling, a house, isn't available for rent or sale when in fact it's able to do so. So if you think about it, even though it's a lot of legalese, it's pretty straightforward. You can't tell people property isn't for sale or rent. You can't give terms that are different based on these protected classes in sales or rental, and you can't refuse to assist someone in the sale or rental of a property based upon those protected classes.
I love that. That's a great breakdown. Trying to keep it simple for all of us, saying, hey, here are the avenues it relates to. And while it is very broad and intimidating, let's boil it down into a bite-sized kind of way to understand it. So that was excellent. In the sense of just kind of, fair housing focuses that HUD has been trying to get more awareness around, are there certain areas within the real estate community that they're trying to kind of get more focus on?
Yeah, they really are. On the next slide, I think we have some areas, but just to kind of give you the numbers, the numbers go backwards for HUD-Ben. They're 18 months behind. So we know the 22 enforcement numbers here in 24. But in 2022, there were over 30,000 fair housing claims. 70% of those brought by what are called testers that we'll talk more about. And of that, over 53% were related to disability, probably related to animals, which we'll talk about. But there was an increase of over 5% of these three topics: race, national origin, and sexual discrimination or sex discrimination, all of which were the highest numbers they had been since 2005. There's just a lot of problems, it seems, with steering, telling people to not buy or rent in a certain area based upon their race or national origin. And with sex discrimination, it's coming more from the context of actual sexual harassment been by either landlords, realtors, or owners of female tenants in property. So it's those areas have really been have exploded and gotten to the highest numbers we've seen in almost 8 years. So definitely that says something.
Yeah. So yeah, they definitely, with a 5% increase and highest they've been in about a decade, it seems like there's been some focus on those three avenues as well as the ones that they're already, doing a good job on enforcing. So
absolutely
good to know. So I think this kind of gives us a natural segue into our next portion, which is going into some specific areas. Now, I know when we first were just kind of talking fair housing complaints and just kind of what is going on with fair housing, you discussed disparate impact, and we kind of talked about it a little bit, but can you discuss how it relates to real estate and fair housing and what's going on with disparate impact?
Absolutely. It's definitely the hottest topic we have in this area. And, disparate impact is this concept, as it says on the slide, that a practice that can look neutral, totally normal on its face, even if the terms of it, the way the words are written, are neutral in their intent, but they can't be maintained because they have a discriminatory effect. It's sometimes called unintentional discrimination, but again, it's a facially neutral policy, but it has a discriminatory impact. There's two primary examples that we use when we talk about it. This all disparate impact originated really out of the lending world. There was a disproportionate of loans being made to certain parts of the country where there just wasn't as many banks or mortgage company offices as there were in other parts. And what the federal government found was in the fair lending context, in certain areas like South Texas, there weren't branches that were available, and that had a negative impact to protected classes such as those based on national origin, folks from South America or Mexico. And so it was like, well, it's not meant to be discriminatory that we just don't have a branch over here on Main Street. We just don't. But this effect of not having access to it made the problems occur. Now, in our rental and real estate world, the examples they're using most frequently are, it's kind of easy to understand. It's perhaps it's a covenant in an HOA, or it's a rule that a property manager has that says, so it's not to disrupt others around you. You can't have more than 2 911 calls in a 6-month period, or you're subject to eviction or fine in an HOA context. The problem with that is that although that makes sense, like, okay, we don't want to have people be disturbed, the people that call 911 the most and most frequently are women and children due to the high levels of domestic violence that affect them. So you could have on this very facially neutral look, we're trying to keep the peace for everybody and be quiet, an unintentional discriminatory effect where women and children or women with families could be subject to either a penalty by an HOA or eviction because they're having to call 911 more frequently just because of the fact they're protected classes. So it's something that kind of makes your head hurt when you think about it, but it's very, very forefront with HUD right now, and it's going to continue to be for at least the next few years, especially in this election cycle.
Yeah, that makes sense. It sounds like a lot of stuff is going on there in the sense of just kind of everything that it covers, but also just kind of the relevance of where it's at. And like you said, it came from the lending world and how it really helps make sure that unintentional discrimination doesn't happen on, policies that seem like they should be okay, but maybe they impact people more than they should.
That's exactly right. And especially with our property management friends, they may have had policies for years, Ben, which now suddenly will be subject to scrutiny. So that's why it's so important to talk about it.
That makes sense. In terms of the evolution of disparate impact, are there ways that it's changed in the last decade, or just kind of ways that, people need to be aware of kind of the ways that it's evolved or changed?
Yeah, absolutely. This is the history of it. It's the great slide you have up here. This helps everybody sort of understand the time frame. This came out in 2013. And again, it came out of the concept of this fair lending platform. And this is the way they described it back then. HUD said that a policy that has a discriminatory effect on a protected class is unlawful. And you had to prove as the person making this policy that it served a substantial, legitimate, non-discriminatory interest, or that there was no less discriminatory alternative that could serve that interest. So it set this big bar for us as the professionals, the realtors, the property managers, to have to show this. They then in 2020, right before the pandemic, it was a brand new rewrite of the statute, new proof requirements, new defenses. It was this huge burden shift. And as an industry, we were gearing up to fight, but then COVID happened. And then nothing happened. It just went away. So now within the last year, unfortunately, HUD is back, bringing back what the changes they wanted to the 2020 rule, which are going to create just a number of traps for the unwary. If we're not sure about our policies, and it's a high priority for the current administration and will continue to be, and for HUD, because remember, although there are political HUD appointees, there's staff that remains in HUD, especially the fair housing enforcement folks, who they're career people. They're always going to be there, and they're always going to be really the ones driving the bus much more than the change in politics. But it is definitely something that is going to be affecting us now going forward for at least the next 5 to 6 years.
That's really good to know, especially because, like you said, it kind of it was getting some attention, then it kind of disappeared, with COVID, but now it's it is back, it's in the forefront, it is a priority. So it is something that we all need to be aware of and be more familiar with, because it's back and it's not going away. So
you need to understand it. And it is, again, it's a bit of a brain puzzling concept, but it's one of those things we really need to learn about and take educational opportunities like this to talk about.
Perfect. Well, that leads us into our first Mythbusters. We're going to pop up a poll on the screen here. We've got 2 scenarios for people, and I want to know real quick, let me launch it. We have 2 scenarios, like I said, so take your time to answer them. We'll give you about 60 seconds. The first one is, you're working with a property owner who doesn't want to lease to people with a criminal background. Is it legal to screen for a criminal background? And the second one is a potential tenant meets the income requirement but has low credit and is considered a risk. Can you charge a higher leasing fee because of this? So we got three different answers. We've got yes, no, and it depends. I can tell you throughout all of our questions, we've got a little bit of all of them. So it's not going to be the same answer every time. So we're going to give it another 30 seconds or so to trickle in answers. I see them already coming in, and really appreciate y'all, putting your answers in for us here. And we're going to hand it over to Monica in about 15 more seconds to answer these questions for us and let us know what the correct answers are here. So, all right, we got a few more answers trickling in. Really appreciate all y'all answering it. Some great answers coming in here. All right, I'm going to end it and we're going to let Monica give us the answer now.
Okay, so on the first one, right, you're working with a property owner who doesn't want to lease to people with a criminal background. Is it legal to screen for criminal background? The answer is usually it depends, but more towards yes, right? Because the idea is that in the property management world, it is fine if you want to include a criminal history or criminal background as one of your criteria. You just have to treat everyone that has that criminal history the same. So in other words, if you deny everybody who says, have you ever been convicted of a felony, regardless of what it is, when it was, but you just deny them, you're good, right? Where you can't get into it is you can't say, well, that one was 5 years ago, but that one is 10 years ago, but it's the same crime. Some of my property management clients, they are very clear where they say this type of offense, for example, if they're arsonists, right? They're never going to get approved if they've been convicted of arson. But let's say it's a drug offense. They're okay if the drug offense is over 10 years or over 7 years. So all you have to do is just be sure your policy is the same if you're going to be using the criminal criteria for it. I don't think it makes total sense to say, I'm not going to ask them about it, because we know that it is an important part of factoring things in. But just be sure you are absolutely consistent across the board with whatever your criteria is. Now, the second one, the potential tenant meets the income requirement but has low credit and considered a risk. You cannot charge higher leasing fees. Now, before you all start throwing things at the screen, I know lots of you do this. Like I know you do, because I represent you. You've told me you do it. I am just telling you, it is just not the best idea to have different fee structures based upon credit scores, because this could go back to the reason why someone has a lower credit score is because they're part of a protected class, or because they didn't, what if it's a mother that was divorced and couldn't have jobs because, the fact that she's trying to take care of her children. This could get into gender, this could get into families. So just my personal Monica advice is don't have scores connected to the credit, because credit sometimes can vary, or not vary, can be tied very closely to the protected classes. And again, I know a lot of you are doing it, so take it for what it's worth, but my personal vote would be don't do it.
Some good answers there. I really appreciate you giving us some more, insight on that, and just some best practices to consider, especially on the charging of, higher rent. That sounds like some good advice there of, hey, maybe you want to avoid this and not step in some hot water here. So we're going to move to our next topic, Monica, and I was hoping we could talk about how HUD is looking at kind of sexual discrimination. I know you said that has been a focus for them. So can you talk a little bit about what HUD is, looking at when it comes down to sex and gender and sexual discrimination?
Absolutely. The case that's on the screen, Bostock versus Clayton County, comes out of my state, Georgia. And that's the case that came to the Supreme Court that broadened the definition of gender to include sexual orientation and identity, saying that the concept of someone's gender and sexual orientation and gender identity are so put together, they call them inextricably linked, that you can't separate them from the two. So although the law has not been actually amended to include that, this case, by virtue of the fact it came from our Supreme Court interpreting the laws, is the law of the land. So there, again, ethically, most of the folks on this call, as members of certain trade organizations, have been unable ethically to prevent this. They can't discriminate based on sexual orientation and identity for ethical reasons. But now if you're dealing with an owner who perhaps doesn't understand, or a seller, you can now say it's the law. And HUD has been enforcing that very, very strictly. The second thing is that there's been just this increased amount of, like we talked about, Ben, reporting of claims based on sexual harassment. Coming out of, I think it was California, just about 2 months ago, there was a $633,000 fine that was levied against owners of rental property and the property managers based upon the harassment of female tenants. The tenants were basically were told, you're going to be evicted unless you go on dates with me, do this with me, and all these other suggestive things. And the female tenants brought this claim, and the hit was extremely hard based upon the fact that it was all based on their gender and a retaliation effect to it. So there's been a lot of eyes on this. This is also very true in the concept of sales. If you have depending on, and it goes both ways, Ben, with gender, depending on, it's just opposite sex, that someone feels harassed in the process of either being shown houses or selling houses based on their gender. It's just a heightened area that we're seeing more reporting in. And again, it's not just going to the property managers or to just the real estate agents. It could be going to the brokerages or to the property management companies themselves and the owners. So really something to watch out for, and obviously be sure you have good policies and training that obviously says, no, we don't do that. We don't treat people that way based on gender.
Yeah, that's good to know, especially with how far it extends to. So the liability, it doesn't just end with maybe the person who was violating it. It can extend further amongst that. And I imagine some of this has to do too with just as the market gets tighter and rents continue to go up and it's a more competitive market, some of the bad apples and bad eggs out there see it as an opportunity to maybe start, going outside the lines of what's acceptable. And that might, also be kind of maybe why we're seeing a rise in it. I don't know.
Yeah.
That's just an assumption on my part.
No, it's a good set of facts, because yes, that's true. It's when people become more desperate for looking for housing, right? That yes, we sometimes have these bad players, these bad apples, doing things that then, hurt the industry as a whole. But no, you're very right that the circumstances often dictate the bad behavior.
Yeah. Well, that takes us into our next Mythbusters. We've got one here, only one for this section here. So I'll switch over and launch it. And the question is, you are a single female landlord and you're looking to rent out a room in your house. Can you only rent to females if it is a safety concern? So this is your house, you're living in it yourself, you're looking for a roommate maybe, to help with the mortgage and pay that house off instead of 30 years and 10 years. What can we do? Can we do that? Yes or no? So since we only have one here, I'm going to give it another 15 seconds or so. I see a lot of answers trickling in, so we really appreciate y'all giving us your thoughts and feedback. And we'll close it down here in another 10 seconds, give or take. So what do we think? Can you do it? Yes or no? Or it depends. All right, it looks like we're slowing down on answers. So I'm going to turn it over to you, Monica, and I'm going to end the poll and share the results here. Monica, what can we do on this one?
Okay, so the technical answer is, you said, that's interesting. We had a lot of yeses. Actually, I would say the technical answer is no, right? You couldn't list the property for rent by saying females only, right? That's no different than saying, whites only, or, no children. It's the same thing. However, right, as the female landlord, you certainly have the right to screen, right, based on other characteristics, right? It doesn't mandate that you have to take a male tenant, right? It doesn't mandate that at all. Just be sure you have screening processes that would allow you to, in essence, get to the same place, right? Well, I'm concerned about having this. Well, look at your screening processes, right? Look at the neutral factors that you can look at where gender isn't a factor in that. So the end result will be that, yeah, you'll end up probably not at all renting to someone who, is a male, if that makes you uncomfortable for safety, but you couldn't advertise it as female only. You just have to be careful with that. Again, it's all what you do internally, right? Because if you can show internal neutral factors, you still are going to be able to get to the result that you're looking for, like in this scenario, but without a discriminatory effect.
That's a good answer. And it comes down to the devil's in the details. How you got to have that neutral process. You can't necessarily advertise, like you said in the listing, that it's females only, but you can consider your process and look at that to maybe help you get to the same, end result, but legally in the appropriate manner.
That's right.
So, all right. So I'm going to stop sharing this one. All right, we're going to move to our next one now. And this is one that you said was a pretty common violation. We're going to get into familial status. So, can you explain who's protected with familial status and how it relates to fair housing laws, Monica?
Sure, absolutely. Basically, it's this idea that a family is a family is a family. It's not for you, me, whomever to decide what makes up a family, right? It could be the grandmother with her sister and two kids. It could be an uncle, his nephew, and a wife. It could be two dads and their children. There's no definition of what is family, right? It also goes to this concept that you can't say no kids allowed, right? Because that would bar, right, the ability for children to live in a community. Now, obviously, this is not talking about friends, like our senior communities, like, Sun City, where my parents used to live. Those have a special carve out based upon their approved language that they have in their covenants and restrictions. We're not talking about senior communities. They're treated differently under the laws that they have. But it's the idea that you couldn't say no kids allowed because, your owner, say in a property management context, thinks that kids are messy. They're going to mess everything up, right? And some of the enforcement actions have run the gamut from, children, like there was one recently where kids were, there was a prohibition on the hours that kids could be outside. And they were ridiculous. They were like, they can't be out past 4:30, right? So someone brought that as a claim in an apartment complex, and HUD said, yeah, that's not fair. That's not reasonable because it's not, you're not letting basically kids be kids. And so the penalty in that one, interestingly enough, was the owners had to actually build a better playground for the kids. It wasn't a monetary one like money going into hands. It was something like that. The other one we see a lot is unrelated people, right? That sometimes this what is a family is a family. Let's take out for a second any laws that talk about unrelated people living together, people unrelated by blood or marriage. Sometimes a family in some states, in some areas, are going to allow an unrelated person to be part of the process. So again, this is an area that can get very gray. So better to always be consulting with your laws or with your lawyer or checking with HUD. Lots of good information on the HUD website if you're not sure.
I love that. And I love the penalty too on that one where they couldn't play after
Yeah.
4:30, like, all right,
Yeah.
this is ridiculous. But to even like, a little salt in the wound, we're gonna make you guys make the playground better, which is gonna encourage them to play more on it.
Yeah, and
Um,
that's exactly right because that was promoting, right, the idea that look, families are families, and yes, you have the right to make reasonable rules, but again, this goes back to everything we're talking about. You can't have a rule that ends up, having either an unintentional negative effect or here a direct effect on the enjoyment of the property or the use of the property, I should say, not enjoyment.
That makes sense. And I think, this topic in general, it doesn't shock me that it gets a lot of focus because in my program in, the Masters of Education, we've been talking a lot in the classroom of understanding blended families. And a lot of families have a lot of different non-traditional backgrounds compared to what teachers were used to previously, decades ago. And so, it's kind of the same thing here in the housing laws where it's like, listen, we got to understand that there are a lot of different ways that a family is a family. So we got to respect that and be conscious of it, is what it kind of sounds like to me.
Yeah, yeah,
Perfect.
absolutely.
Well, we got two Mythbusters here, y'all, for this one, and I'm going to post these here. All right. So the first one is you get a qualified application that meets the occupancy standards in your locality. The tenants include a single dad, his brother, three daughters, and his friend. You're concerned about having too many people in the unit, maybe because of wear and tear or whatever. Can you reject the application because the friend isn't a family member? And the second one is a mother and a father have one child and live in a one-bedroom unit. They then have a second child. Can the landlord suggest that they move because they need more room due to the growth in their family? So we got two really good questions here. We're going to give you guys another 30, 45 seconds, give or take, to kind of answer these. And Then we're going to dive into them and see what the answer is for this. So I think both of these are really good ones. Monica and I talked about these at length a little bit, and there's some interesting facts on these ones. So I'll be interested to see what y'all come up with your answers. It looks like we're getting a mixed bag here of different answers trickling in here. So we'll give it another 10 seconds or so for everyone to get their answers in, and then we're going to hear what Monica has to say so that we get it right and know what we can and can't do. So, all right, it looks like we're slowing down on answers. I'll give you 5 more seconds. If you're going to get an answer in, get it in, get it in, get it in. All right, Monica, I'm going to end it and share it, and we're going to hear what can we do?
Okay. So on the first one, I sort of gave it away. Oh, very good. Yeah. It depends or the nose. I think that's exactly the way I would go to. It really depends because I think you're walking a very fine line if you are just looking at that friend, right? I think that you can really run into trouble because they could argue, well, look, this is still, look at this blended family, look at what we have, it's difficult. In fact, it's Full House, that show, right? It's exactly, or I guess it was his brother-in-law, Uncle Jesse was his brother-in-law. But yeah, it really depends. I would probably, especially if it meets the number of occupants in a home, I would probably lean towards approving it. But again, using your neutral factors, right? That's the way to do it. I saw that we had a very good question in the chat about this, about renting to unrelated people. Like, for example, if you have a bunch of college students, right? Now, that is very different, right? Because if you have 4 unrelated people, you live near Emory University here in Atlanta, and you have a house, and your landlord or your owner says, I don't want to rent to college kids, right? That is almost never considered discriminatory because, one, they're not related, right? They're not a family. And two, you also can always look at your occupancy standards. So that was a really good question. Now, the second one, the answer is absolutely not. And in fact, this was a recent enforcement action where it was out of, I believe it was Illinois. The people lived in a 1-bedroom apartment or unit or whatever, and they have the second baby, and landlord starts coming and PM starts coming in saying, well, you really should move. There's too many of you in there. You should move. No way. That's complete discriminating against familial status. If they all want to be crunched in there together with a crying baby and another little kid, that's their right and that's their protection. And in this case, the owner, the property manager, got hit with a substantial fine just for suggesting that they go elsewhere, move elsewhere. So you got to be really careful.
Yeah, that's interesting. It sounds like even if it's well-intentioned and you're not meaning to discriminate and you're just kind of like, oh yeah, you've grown, maybe you need more space, and you're thinking like, oh, I'm trying to upsell them or something. Maybe not, the smartest thing to do. It sounds like it's something that gets frowned upon, and while it might not be intentional on your behalf, but something we probably don't want to be doing and just trying to avoid here.
Yes, absolutely.
Well, we're going to go into our next section and we're going to switch this one up mainly because there is a lot in there and we want to see, just because it's such an overarching category, if what you guys know on the forefront. So we're going to go into disability and we're going to start with some Mythbusters here before we talk about it. So I'm going to launch them real quick. We got 3 ones here. You are highly allergic to pets and want to list your house as no pets allowed. We're assuming you don't live in it. Maybe you're intending to come back after a year. Is this legal? Can you do that? Number 2, you're listing a property in a community where the HOA, bars all pit bulls. Can you refuse an applicant who has a pit bull as their emotional support animal? And number 3, tenant who moved in with an emotional support animal is moving out and the animal damaged the property. Can we use the security deposit to cover some damage? What do we think, y'all? I see some answers trickling in already. I know we got 3 here, so I'll give you guys a little bit more time to answer this one. We'll be interested to see what you say. Again, we're not quizzing you for accuracy. You're not getting a certificate at the end if, you get 100% or anything. We're just interested to know before we go into this one, what you guys kind of know about, disabilities and what they do and don't cover. So we'll give it another, about 10 to 15 more seconds. I see some answers trickling in, so let's get those answers in. If you're sitting on the fence and you're not sure, let's get it in and we'll give you the answers here in a few more seconds. All right, we're slowing down here. I'm going to end the poll and Monica, tell us, what do we need to know about disabilities here?
Yeah, go back one slide. Don't do that slide yet. That's
Oh, sorry.
our dreaded pet slide. But yeah, yeah. So the answer to number one is right. Sure, I can list it as no pets allowed, but what happens when the person comes in and says, "Well, I have an emotional support animal," right? When he does click to the next slide, it's that slide you've all probably seen a million times in people speaking on this. Emotional support animals, service animals, they are not pets. So, to approve them, we'll talk about that in a minute, is there. So you can feel free to list it as no pets allowed, but if someone comes in and says, well, I have a service animal, seeing eye dog, or an emotional support animal, you're going to have to put them through the screening process. You can't deny them unless there's other criteria available. This one with the HUA comes up all the time, right? They have breed restrictions, weight restrictions, but if the applicant shows that it's a valid emotional support animal who happens to be a pit bull, even if it is a restricted breed or weight, you still have to allow them to come in, again, so long as they're appropriately approved, right? Now, the third one, a tenant who has an emotional support animal maybe scratches all over the door, you absolutely can use the security deposit to cover the damage. Because remember, the emotional support animal or the service animal, they're not considered a pet. They're like another being or person, right, in the unit. So if I went and scratched up the door, right, you'd cite me for that. It's no different than if the pet did it themselves.
All right, I'll stop sharing
Good.
it. And now
Yeah,
we'll
look at
get
that.
into the
Oh,
nitty
that's
gritty
interesting.
here.
Yeah, good. Good. People got it. Yeah, good.
Yeah, a lot of people got that one.
Yeah,
So,
that's good. Yeah, that's because they all know this one. And this slide, they're all going to be like, oh, not this slide again. But just read it with me, everybody, because it's still the number one area of complaints, right? 60%, now about 57% of all HUD complaints are disability related, okay? If you have not, take a picture of the screen if you need to. If you have not pulled off the internet, the FHEO 20-01, this is the document that's define your own adventure, right? And it tells you, is the pet, is the animal a dog? Yes. And it runs you through the whole criteria for how you approve, what you can approve, what you can ask. It is from HUD. And again, it defines what a service or support animal is. Remember, just keep saying to yourself and to your staff, especially your remote team members, that properly documented emotional support and service animals, they are not pets, okay? They cannot, therefore, have extra fees associated with them. No pet fees. They're like the person, right? You can't refuse them, but you can ask for verification. And HUD, in that guideline up there, that FHEO 2020, gives you exactly what kind of, type of form is not appropriate. We see these all the time. They're perhaps, bought on the internet for $75, right? You can push on the source of verification, right? A valid verification, again, I always use the example, Ben, out of Chicago, the child that was autistic had a bunny he needed to pet. The landlord, property manager, owner wouldn't let the bunny stay. They had letters from therapists, psychologists, medical doctors, right? Those are all valid sources, right, to come from. And so they were fined quite a lot by not letting the little bunny stay as an emotional support animal. But again, if the bunny did something horrible and, chewed a hole in the wall, you can assess the damage caused by that animal at the end of the lease. So a big tip for everyone on here today is if you have not, especially if you're an owner or broker, you want to pull that FHEO 2020 and slap it on your wall because it is an absolute guide to how to stay out of trouble in this area.
it sounds like a must-have thing. So in case y'all didn't hear that, print that out. That is, if you take away one thing from today, print that out, put it on your wall, make sure you're paying attention to it. And I also love the distinction of just saying they're not pets. Like if we
Right.
think in that manner, I think it makes it a whole lot simpler to just say they're not pets, and
Right.
really understand that. So we've got two more Mythbusters to wrap up our disability section here. And this is just kind of extra credit ones here to take us a little further. And I'm going to launch these here in a second. If it would let me. I'm having technical difficulties here. Sorry, y'all.
No problem.
Well, I thought I was gonna launch them, but it's not letting me on this one. It looks like one.
That's
Oh, I
okay.
didn't stop sharing. I'm sorry, y'all. That is technical difficulty on user.
There
My
we
fault.
go.
All right, here's number one. You receive an application but are skeptical about the applicant's disability. Is it legal to ask them what their disability is and to provide proof? Number two, you accepted an applicant who disclosed their disability to you beforehand. They require handrails to be installed in the bathroom due to their disability. Is it legal to refuse to install them and require the tenant to pay for it if they want it? So, two really good questions here. One outside the scope of animals, though. So, we're throwing you guys a bit of a curveball here. So, I'm going to give you all about another 30 seconds or so to get your answers in. And then we're going to get some answers, and then we will move into our next section here. So, what do y'all think? Is it legal to ask for proof if you don't believe them? Or for the handrail one, whose burden is it to install those handrails? So give it another 10 seconds or so. I see some more answers trickling in. So really appreciate y'all getting those in. So, all right, final countdown, y'all. 5 more seconds. All right, Monica, I'm gonna share the results here.
Okay.
And what can we do with this one?
Sure. So the first one was a little bit of a trick question. So yeah, and people answered it very fairly. So you cannot ask, right? You cannot ask what is your disability. Now sometimes it's obvious. They're blind. They're missing, they're a veteran and they're missing a leg, right? But remember, there's lots of disabilities that we cannot see, right? We can't see depression. We can't see anxiety. Probably can't see things like autism, right? So you should not ask them what is your disability, but you absolutely have the right to ask for proof, especially if it isn't a non-visible, right? You know, if it's not, if you don't look at them and immediately say, oh, you're blind, you have only, you know, you're missing an appendage, right? You absolutely can ask for proof, whatever it is. And the proof needs to also talk about the need for the emotional support animal or service animal. And usually that alone will then tell you what the disability is, right? But obviously, if someone's in a wheelchair, you're not going to be like, what put you in the wheelchair, right? You're not going to do that. Now, this one right here, I actually had this case for a client here in Atlanta, and they got into a ton of money. They actually refused the applicant. They wouldn't let her install that, like a little chair, a handrail to transfer from her chair to this stool over into the bathtub, and they got into a lot of trouble because no, you have to. That's a reasonable accommodation, right? When we get into disabilities, we talk about reasonable accommodations. It is no different than if someone said, "Would you please install a ramp into the house?" That is not an unreasonable accommodation. Now, if it requires things being built and stuff like that, at the end, right, you could ask the tenant to pay for the removal of it, but you can't as long as it's not going to cost, you know, $1 million, because that would be unreasonable, right? You can't refuse that. So in this case, my client unfortunately had to pay a lot of money, even with me trying to negotiate a lot of different things, just because he wouldn't let them install it, and then, you know, went a different route saying, well, if you're going to do it, you need to pay for it. So just that was very good. Everybody who answered no, that's the correct answer.
And I remember us talking about this one before we kind of, really got too heavy into the presentation. And it was interesting hearing about the case and everything. So this isn't, just a theoretical issue. This is a real case. Monica has actually litigated on one of these. So for all y'all, when you run into this one, hopefully this triggers your brain to say, hold up, wait a second, I need to think this through here. Well,
That's right.
a lot of good information here. We're going to switch gears now, and we're going to go over how to handle a complaint and how to reduce the risk of receiving a fair housing complaint. So let's start it off with what you should do if you do receive a fair housing complaint. Can you talk about that some, Monica?
Absolutely, yeah. The number one thing is the third bullet point down. Do not be an ostrich with your claim. Do not throw it to the stack over here. You must take action. And whether that's talking to an attorney or even talking with the person who sent the letter from HUD, but you must train your staff, especially your remote team members, that if somebody threatens a fair housing claim or you get an enforcement action, it needs to be delivered. This is a top tier action. This is no different than a lawsuit. The top person in the organization needs to have it, right? And we've talked about a lot of recent examples, but one thing I want to bring to your attention is the use of what are called testers. Testers are people who are individual groups who basically their job is, some are actually funded by HUD to go, they're like secret shoppers, if anybody remembers those from back in the day. They're there to see how compliant you're being, right? There was a case that came out recently where testers called leaving voice messages, three of them, and then a different tester called left 3 messages. The first 3 were not returned because the person had a very clear, distinctive ethnicity to their speaking voice, right? They spoke with an accent. The 3 that were returned, people clearly spoke with what could be deemed a non-person, a white person, not a person of color's accent. So that group got hit. And then what happens is these testers they get a cut of whatever the fine is. HUD is promoting the testers. They want them out there. So again, in theory, it sounds great, but for our industry, it puts us even further under the microscope. So you should almost always assume and train your folks that it could be a tester, somebody testing to see if you know your policy at the end of the line. Documentation is critical, right? If someone is taking a call, this is why your remote team member training is so important. You need to train them that if someone says, well, I don't have a pet, I have a pit bull and it's an emotional support animal, that person has to be trained to say, well, we need your documentation, but they also should be trained to keep note of that call. So you know right from the beginning that the property at 123 Main Street got this inquiry about, can they have a pit bull? Can they have an emotional support animal? Because it makes it so much easier at the end of the day for me or a lawyer to defend you if you've documented it. In enforcement actions, finally, there is this concept called conciliation or working it out. While I am all for, as an attorney, always to working things out through mediation or settlement, the problem with HUD's conciliation is that they're not private. And so you will be somewhere in the HUD website. You probably won't be Channel 2 News front and center, but you will be forever captured in their website as this company settled with this complainant over this claim for this amount. So I have many clients that just don't want to go through conciliation because it just isn't a private process. But the biggest thing would be number 3 right there in the middle. Don't be an ostrich. You've got to act and react when you get one.
Love that. A lot of good advice. And I also really like you talking on the documentation side because, the reality is, and I'm going to refer to the commission stuff. If it's not in writing, if you don't have it in writing, it doesn't exist in the legal world. And that goes to the same with representing buyers, that goes with representing renters, and this goes with fair housing. If it's not in writing, it doesn't exist. Or as Monica said, it's very tough for her to defend you on a he said, she said kind of thing. If you have it in writing, you've got those call reports, it gets a lot easier to create a paper trail and understand what actually happened and what are the facts. So right. Really important there. Let's now look at just a few ways that someone can minimize their risks of receiving a fair housing complaint. Can you go over a few things that people should be doing? I know we just talked about a few, but I know you got a few more ones that are also good. So let's hear those.
Yeah, absolutely. And these are, again, this is like when you're printing out that 2020 guidance, this should also be something that you, especially if you're the broker, the owner of the company, the manager, you need to be sure that when you are either selling a home to someone or placing someone in a rental property, that you have a written neutral process, right? Someone comes in to buy a house. Look at things like, are they paying cash? Do they need a loan, right? How quick can they close, right? Things that basically are going to be neutral, right? Things when you're renting to someone, someone asked in the chat, can I ask, have they been evicted? Absolutely. That's a huge factor to know something about their history, right? But look at things like credit scores or eviction history, right? Those things are neutral across the board, and they're not based on any of those 7 protected classes. Treating everybody the same, and not to be weird, but assume that if someone's on the phone asking weird questions, maybe assume somebody could be a tester, right? But treat the applicants the same, ask them the same questions. If you need to ask questions, it's okay, just do it. that's a good thing to do. Train on issues that can be tough, right? Having next time one of these webinars come up, have everybody get around with some pizza and watch it, right? Take a coffee break or a pizza break. The more you can train, the better it is. You also have got to have friends who are owners, an escalation process or brokers. This goes for both the retail side as well as the property management side. Your people that work for you have to know what to move up the food chain, because again, if HUD gets no response to a claim, there's very many instances where they assume guilt. They assume that you're agreeing with the charges. So you have to be sure your staff knows when and how to escalate it. Again, we've talked about documenting it. I know that nobody, if you could see my messy office bin, it's full of paper, right? Because I'm old, but you document it in your internal systems, right? Nowadays, most of your management software for property managers have this ability to look at the phone calls, what comes in. If you're listening to this and you're a sales agent, you're still going to have probably text communication. Document what happens. Having protocols across this whole board are absolutely the way to stay out of trouble, right? Just fix certain protocols in terms of how we screen, how we approve, read, engage. HUD has fantastic information on their website. They have little quizzes, kind of like Ben was just doing. They have little recorded sessions. Pull those out once a month at a sales meeting and play one for everybody, right? And the final one, and this is real important, it might be a little unpopular, but not only educate your owners, because oftentimes they're named right along with you, either if they're the seller of a house in a retail transaction or the owner in a leasing transaction, educate them about this. But also, friends, do not be afraid to fire them if they are not following your advice. You are the experts in this situation. You're on this call, you're learning, you're trained, you're licensed, you know better. So if the owner is telling you, I can absolutely refuse to rent to that gay couple, your answer is going to be, that's against the law, and I am firing you, because guys, if you fire somebody, another one will come along. But don't be afraid to put your expertise out in front, because you are the experts in the room on this topic.
I love that you reiterated that, because it's so true. You are the expert, and in the court's eyes, in the pecking order of who's the most culpable, you're at the top. You are the expert. So, you got to understand that. And also, as Monica says, don't be afraid to fire clients. I know a lot of people out there are worried, but a lawsuit is a whole lot more costly and more of a burden than losing a client who you have to replace, who's not, following the law. So, a lot of great content that we went over today. Monica, I really appreciate you going over everything here. We're going to go into just some next steps and then get into our Q&A. I know everyone always likes a little bit of next steps on how we can keep the momentum going. So we got 3 things for you that you can be doing as you get, moving forward out of this webinar. Number 1, create and check your escalation protocols. Monica was talking about those. Give those a look. Make sure they're appropriate. Make sure they're neutral. Also, let's review our application and leasing process. Again, it goes back to that neutral element. How are we documenting it? What are we doing to make sure that we're staying neutral on face value? And finally, I encourage all of y'all to make it a habit to have quarterly training to stay current on fair housing topics, and make sure that your staff is educated on them, so that you're actively always working on, hey, this is a tough scenario. Let's make sure we know how we're going to, handle this as a team. So those are 3 things that we can do to, keep the momentum going. And what we're going to do now is we're going to go on to Q&A. And I'm going to pop up another poll. This one is just to help us do better. We're looking for your feedback. We want to know what you want to hear more on, topics that you're interested in, and then what we can do better. So if you guys can take a minute to just, answer these at your own leisure, we would love the feedback. So while you guys are getting questions in, I've launched that. We're going to dive right into our first one. So Monica, the first one I'm seeing here is, can I not rent to someone of a certain occupation, or is that covered by source of funds?
That's a great question. Yeah, and there's a few of you I've tried to answer as we've been talking when you're voting, but that's a good one, right? So it's not so much that you can't rent to them because they're a certain occupation. In fact, I have many property management clients who refuse to rent to lawyers because they're a pain. Go figure, right? But source of funds means where your money's coming from. So for example, I am a disabled person and all my money comes from disability or Social Security income, right? You can't refuse them if they qualify otherwise, right? Just because the source of their money is disability income or Social Security disability income, right? Same with what if all their money comes from VA, they're a veteran, VA funds. So it's not so much looking at what they do. And this, again, this is not the law across the whole United States. This is very much our friends on the West Coast, God love you all, who have very strict things about the source of the funds, right? Like, again, if I'm Section 8, you're having to, not say, well, you're Section 8, I can't approve you. Now, what I say about Section 8, this is true pretty much across the country, except for some parts, Washington, California, Oregon, you can say, look, I don't have any Section 8 housing available, I can't help you, and that's not discriminatory. But it's not so much the occupation, it's the idea with source of funds is where's the money coming from? You can't say, well, gosh, all your money is coming from, disability insurance, SSI, I can't rent you, something like that. That's what would get you in trouble. Because again, people love to say, I'm not renting to lawyers. And that's just fine.
Some good clarifications there. Really appreciate you giving us some insight on that one. This one's another kind of clarification question on what you were talking about. And I think you kind of touched on it when you were talking about the handrails, but we just want to make sure we're clear here. And the question was, so if the modification is not outrageously expensive, the landlord must pay for it. They cannot ask the tenant to pay for it?
That's correct. And this is where it gets a little weird. You can ask for them to take it down when they leave. So it's a reasonable accommodation to put it up. And yeah, and that again, reasonable accommodation, very much in the eye of the beholder, right? Kind of a Monica tip here. If it's like under $200 or $300, it's going to be probably unreasonable to not do it, unless your rent is like $100 a month, right? But when they leave, they have to pay. You can, if you want, charge them to turn the property back to before it was. So you can't charge them on the upfront, but you can charge them on the outside if you want to take it down. Now, sometimes the accommodation is so minor, it doesn't matter. But, if it really was, like if the ramp is an eyesore or something in the neighborhood or whatever, or not allowed in the HOA for a non-disabled tenant, you can charge them on the takedown. But yeah, but reasonable accommodation still has some wiggle room for you all as the professionals there. So just, use your common sense.
Perfect. Perfect. Now, I know we kind of talked about this one, and I have a feeling I know the answer on this, but someone was saying they had someone call in with a very large emotional support dog in a condo building, and they basically told him, hey, I need to check the rules, and the person threatened to sue them then. She's asking, can I not even say I have to check the rules? Is that too far?
No, that's perfect. You handled that perfectly. And in fact, that tells me they're either a tester or they're just honestly misinformed. But no, you absolutely can say, I need to check. And this is how your staff should be trained, right? If you're remote team members, whatever, if they're not sure, well, I need to check the protocol on that. I'll need to get back to you. Totally fine response, but just be sure you do get back, right? With an answer, right? So like with that one, if it's a very large ESA, your response back is going to say, well, I checked the rules. I just need to see proof that this animal is in fact an emotional support animal, right? And again, if they come back with something that looks legitimate, even legitimacy is kind of within your realm, right, of your experience. Again, we know people can pay $75 to get stuff off the internet. You have a right to dig deeper, right? Say, well, I need to see the doctor or the therapist that approved this. I had someone do that recently, and guess what? The tenant applicant disappeared. Why? Because it was bogus, right? So no, you handled that perfectly. It's fine to say, I need to check into it. So anybody who's threatening you based on that, that's just bad news. But yeah, you were fine with what you did. No worries.
Perfect. I've seen this question a few different ways, but this is an interesting one. And basically it is, a property owner's insurance doesn't cover specific breeds. What happens if the insurance company is threatening to cancel the insurance policy? And how do you kind of handle, an emotional support animal that isn't covered by the insurance policy?
Yeah, that's a tough one. And there's different people who have different views on that. I have one client who feels very strongly. He basically says, I don't care about your insurance. I'll insure it for you, right? He shifts the risk. I think of an insurance company. I think what I would do is I would send the insurance company all the information you have given, showing it's a legitimate emotional support animal, right? It's unfortunately a 150-pound German Shepherd, right? And it's the emotional support animal. I would send it to them, and I would be sure your owner is 100% aware of what's going on. And I would have the owner discuss with the insurance company that the owner in essence is I'm sorry, the insurance company in essence is saying you should be discriminatory, right? So usually it becomes down to a fight between the insurance company and the owner, but it's hard to give you a definitive yes or no what happens. But in my experience, that does happen, and you then as the property manager have to kind of step back a little bit and let that be a discussion between the owner and their company. Because if the insurance company said we don't cover people of a certain color, well, obviously that's discriminatory on the part of the insurance company. So that's why the insurance company needs to be a little educated by the owner, but you kind of step back, let that be a fight that they do together.
Perfect.
Great question.
I know we're 1 minute past, but I've seen one more question coming in variants of ways. Is it okay if I ask it?
Of course, absolutely.
Perfect.
I appreciate everyone being on. We've had a great crowd today.
We really have. So here's basically the question. There are a lot of, bogus sites out there that provide ESA letters and stuff. And they're asking basically what happens when I get one that doesn't seem like I've asked for proof. They provide me with a letter that doesn't seem very legitimate. Is there a way of handling that situation? Do you recommend using a website like petscreening.com to deal with these ESA kind of requests? How do you approach, some of these more, maybe they're real, maybe they're not type letters?
I think it's great in our industry when we do have many, many vendors that can do many, many things for us. We have vendors that deal with, inspecting properties, right, for you to be sure what's going on during, after, and before renting. We do have vendors that deal with pets, things like this. But if you're not going to use a vendor, you have every right under the law to call up from where this came from and push back. I need to, I see that you're out of, I had an example where the number said Texas, it rang to a Florida cell phone, right? And so the person's like, okay, you're in Florida. The person's like, yeah, I'm in Florida. And they're like, all right, so who are you? And, just by asking and pushing, right? Again, a legitimate person is going to have legitimate paperwork. Think of the little boy with the bunny, right? He had his doctor, his therapist, his psychiatrist, right? They should never have denied all that. But a $75 thing that says, oh, this little, chihuahua or this, some crazy animal, this ostrich is my emotional support animal, you have a right to push back if it doesn't look legitimate, if it's not including, perhaps a doctor's name or a therapist's name or a pastoral care person. It could come from someone that's like a religious counselor. But you can push, even if you still get something, push with the doctor. I had someone tell me once that the doctor that was signing it was totally fake. They went onto the medical state, whatever it was, Kansas. They went and looked it up. That person wasn't even a physician. So you could then go back armed with that ammunition to the tenant applicant and say, look, I am not approving, the ostrich, because when I looked, this Dr. Smith, they don't even exist, right? Because again, legitimate real people are going to have legitimate real paperwork. So that would be my advice.
That's really good advice. And just one quick clarification question on that. Working dogs. Can a police officer's training canine be protected or no?
I saw that question. That is a great question. And I'm going to have to get back to Ben on that because that's a really good question. I mean, I would think they're not necessarily an ESA, but are they considered a service animal because of who they're serving? So that was a really, really good $1 million question. If I had the $1 million, I'd hand it to that person. But I'm going to check on that and give that back to Ben. I honestly don't know the answer. It's a great question. My initial thought is that it's like another occupant, right? And that's sort of the idea of emotional support animals, service animals aren't pets. They're another occupant. But I don't know if a canine officer qualifies as a service animal. I'm going to look into it because it's a great question. Really, really good question. But I honestly don't have the right answer for it because I'm not sure.
I saw that one at the end and I was like, oh, I said one more question, but I lied. I'm sorry.
Great question. I'm thinking that maybe the answer is you could get it in under service, but I'm going to have to look, but it's a great question.
Yeah, well, everyone, thank you all for sitting on with us today. I know we went a little long. We really do appreciate you taking time. Monica, thank you so much for lending us your
Thank you.
expertise and your knowledge. I really know that this was great for everyone who was on. So, it's such a pleasure having you present to our audience and provide such great value to them. So, thank you so much, Monica.
Thank you so much. Thanks to Rental Beast. Thanks to Realtor Benefits, everybody. Just appreciate the opportunity. And I hope everybody then put in what the next topic is they want me to come back and talk on, because I love doing it. And again, for everyone listening, there's my contact information. Feel free if I can be of assistance, especially with fair housing, always happy to be.
Perfect. Well, everyone, thank you again. I know y'all got busy afternoon, so we'll let you get back to it, and we'll be excited to see you at our next one in May. We're going to be talking about some lending things in May, so we'll have a fun one then. So everyone have a great afternoon. Monica, thank you again, and we'll see you guys next time.
Thank you. Bye-bye.